Imagine this. You're accused of something that could end your entire career. And then you have to spend years fighting not just to prove you're innocent, but to even get someone to look at your evidence. That's really the core of the story we're diving into today. The case of Professor Dora Kostakopoulou. It's a legal battle that basically puts the whole idea of a fair hearing on trial. And that brings us to the central, baffling question of this whole affair. How is it possible for a legal case to drag on for 3.5 years and then just end, without ever actually digging into the facts of what happened? It's a question that opens up a really remarkable and frankly troubling story.
So, to understand this, we've got to go right back to the beginning. Every major legal fight has a spark, right? An incident that kicks the whole thing off. And in this case, it all started with some very, very serious allegations from the University of Warwick against one of its own professors.
So, back in early 2020, the university suspends Professor Kostakopoulou, and the reasons they give are explosive, trying to influence witnesses and harassing students. I mean, for anyone in academia, accusations like these are not just serious, they're basically a potential death sentence for your entire career.
Then just 6 months later, the university fires her after holding a disciplinary hearing. Now, the context here is absolutely crucial. This hearing, it happened while she was out on certified medical leave. And as the documents show, her evidence and her witnesses were never even part of the discussion. So this dismissal, done in her absence, is what sparked her entire legal challenge.
Okay, this slide, this really gets to the heart of it all. On one side, you have the university's reason for firing her in 2020, student complaints. But on the other side, you have this jaw-dropping admission they made in court 3 years later that actually no signed student complaint or witness statement ever existed. The whole foundation for her dismissal seems to just evaporate.
So, with the battle lines drawn, the case went to the employment tribunal. But instead of getting a quick and clear resolution, it fell into what the source documents basically describe as a maze, a labyrinth of constant, systematic delays.
And we're not talking about small delays here. Just look at this breakdown. We're seeing huge chunks of time where the case just sits there. 7 months waiting for an answer on an urgent application. A full year just to schedule the final hearing. 10 months to get a copy of a transcript. Each slice of this chart isn't just a delay, it's a period where justice was completely on hold. Let's just focus on one of these. 7 months. That's how long the professor waited for a response to an urgent request, basically asking the court to rethink a temporary decision. You know, in a legal system where every day can feel like an eternity, a 7-month silence on something labeled urgent isn't just a roadblock, it's a total dead end.
And this wasn't a one-time thing. You can see the pattern all the way through the timeline. A claim gets filed, then it just sits there for 5 months before anyone's even notified. A hearing that's legally supposed to be urgent happens 3 months late. The final hearing gets scheduled a whole year out. This pattern of delay really becomes one of the defining features of this whole case.
But it wasn't just the delays. At the same time, another really disturbing pattern started to show up. Key pieces of evidence just vanishing, right when they were needed most.
Yeah, the story of this missing evidence is as simple as it is unbelievable. Step 1. Professor Kostakopoulou sends in her 546-page evidence bundle. Step 2. Right before the hearing, the tribunal says we don't have it. Step 3. The hearing just goes ahead anyway. And the result? A critical hearing took place where the judge only had one side of the story to look at.
But wait, it gets even crazier. An official complaint later revealed that the evidence wasn't just lost. Nope. 10 different emails that contained that evidence bundle had been actively deleted by someone inside the employment tribunal. And that changes it from a possible clerical error to a deliberate act. All of this is building to a climax in the summer of 2023. This is where a series of hearings would decide the case's fate, not based on the facts, but on procedure.
And the tone was set before the hearing even started. A regional judge accused the professor in writing of constantly disrupting the staff with phone calls and even restricted her ability to communicate. But here's the thing. Phone records later showed she'd made exactly 1 call in the last 3 months.
So once inside the hearing room, you can just imagine the tension. According to the source material, every single time the professor tried to speak up or make her point, she was just shut down by the judge with 2 simple words said over and over and over. Be quiet.
And that order to be quiet wasn't just a suggestion, it came with a direct threat. The judge's words here make the stakes crystal clear.
If you keep trying to talk, your entire case could just be thrown out. It's an impossible situation.
So then we get to the final hearing the next month, and in a really unusual move, the judge decides to close the courtroom to the public for the first 2 days. The official reason was case management, even though this was supposed to be a final, open public hearing.
So what exactly happened behind those closed doors? Well, according to the professor's formal complaints, the judge's behavior included direct threats. This quote, "You know I can make things difficult for you," sounds less like something you'd hear from a judge and more like a line out of a gangster movie.
Look, this wasn't just one bad day in court with one difficult judge. The documents allege a clear pattern of behavior across multiple judges. You've got one accused of making false statements and hiding the fact that evidence was deleted, another accused of silencing the professor and threatening her, and a third of closing a public hearing and using belittling language. When you put it all together, it paints a picture of a system where the process itself seems to be the main obstacle.
So, after all of that, the endless delays, the missing evidence, the hostile hearings, what was the final result?
On August 2nd, 2023, it was all over. Every single one of Professor Kostakopoulou's claims was struck out. And that brings us right back to the question we started with. After 3.5 years, the tribunal never once held a hearing to look at the actual evidence. The case was just terminated.
And this isn't just some abstract legal argument. There is a real, devastating human cost to all of this. This number you see here, that's just the direct financial loss, or salary, pension, all of it, from being out of work. It doesn't even begin to cover the legal fees or the incredible damage to her career and reputation.
This quote from an analysis of the case really sums it all up. The argument is that what we just walked through isn't just a series of unlucky mistakes, it's a systematic erasure of evidence that amounts to a profound failure of justice. That's an incredibly powerful and damning conclusion.
And all of this leaves us with one last massive question. We all believe in the right to a fair hearing. It's a cornerstone of our justice system. But if the process of getting that hearing, a process filled with years of delays, lost evidence, and procedural traps, if that process itself becomes the punishment, then what does the right to a fair hearing really even mean? It's a question this case just forces you to ask.